The prosecutor is trying to make this case something it's not. You're here because you're going to judge my client, Christopher Schurr, on the decision of whether or not to use deadly force in a situation, on his decision and his belief that he was in fear of either great bodily harm or death. You are not here to judge the GRPD policy. You are not here to judge whether it was reasonable for him to chase Patrick Lyoya. You have to decide whether the prosecutor has proven beyond a reasonable doubt, whether Grand Rapids Police Department Officer Christopher Schurr had a reasonable fear of great bodily harm or death. That is the issue. And you must look at it as to at the moment of the threat. When Patrick Lyoya had the taser in his right hand, whether or not Christopher Schurr was reasonably in fear. And the prosecutor has failed miserably. I want you to look at just the case that the prosecutor put on. And I would submit to you, the prosecutor didn't even meet his burden in their case. You heard from a couple of Patrick Lyoya's friends about what occurred the night before leading up to the events. There was a night of drinking. Mr. Lyoya wakes up at 8 a.m. according to the witnesses who were there. He's with Aime Tuyasheme and David Bakuru. And the prosecutor put on evidence of how much everybody was drinking. That was the prosecutor's case. And that they got into a car. No one is suggesting that anybody should be executed because they're drinking and driving. That's absurd. And that's nothing to do with what happened here. Yes, he was drinking and driving. Is that a bad thing? Yes, but nobody's saying they deserve to be executed, and nothing like that happened. The issue is whether or not he was in fear after Patrick Lyoya later on took his taser. So what happened is they get into a car, and it has a license plate from a different car. That means that the license plate belonged to a totally different car. Mr. Lyoya and Mr. Tuyasheme and another person was dropped off so that person could take his kid to school, and then they drive around. They visit Mr. Lyoya's new apartment. They stop to reload on Budweiser, and they're driving around again. When, according to Mr. Tuyasheme, they hear a noise in the car, and they were driving around. They take a couple right turns. They stopped on Griggs Street in Grand Rapids. And then Mr. Lyoya quickly exits the car to see what's going on. According to Mr. Tuyasheme, he really wanted to hear what the noise was to try to figure out how maybe there was something wrong with the car. But at precisely that moment, in an incredible coincidence, that's when Officer Schurr had pulled him over. You can decide whether or not that was the case, whether or not that's even relevant. But Officer Schurr, it's irrefutable and undisputable, he had a valid reason to pull him over. The plates didn't match the car. He's a police officer, and that's his job. He's at work. It's 8 a.m. on Monday. That's his job. That's why he's pulling him over. And the prosecutor agrees it's a lawful stop. After getting out of the car, Officer Schurr gets alarmed. You can hear it in his voice. He orders him back in the car. 4 times, get back in the car, get back in the car. Why is he doing that? Because he's trained that if somebody jumps out of their car, that could be a problem. So he orders him back in the car, and Mr. Lyoya refuses. Officer Schurr doesn't know why. He doesn't know why he won't go back in the car, but he just approaches him. But he doesn't know anything about a broken down car, because did you hear Mr. Lyoya say anything about, hey, my car's not working? There's a funny noise. No. So we're talking about the knowledge and in the situation of the officer here. So what does he know? He just knows somebody jumped out of the car. Instead of answering lawful questions, which the officer is allowed to do, Mr. Lyoya decides to start questioning the officer. What did I do wrong? And then Officer Schurr is asking questions at the same time. Neither are getting answers. Officer Schurr, he says, you have a license. What for? Do you have a license? For what? Do you have a license? What did I do? Do you have a driver's license? Do you speak English? Because now he's wondering, maybe he doesn't understand what I'm saying. Mr. Lyoya answers that question, yes. Can I see your license? What did I do wrong? And then Officer Schurr just starts answering his questions. He tells him, well, the plate doesn't belong in the car. That's why I pulled you over. He's hoping to get an answer from Mr. Lyoya. Do you have a license or no? Do you have a driver's license? Yes. Where is it? It's in the car. Get it for me. What did I do wrong? The plate does not belong in the car. He answers his question again. Police officers are supposed to ask questions at a traffic stop. They're supposed to get your ID. That's what a traffic stop is. And that's what he's doing here. And if you want to see how Officer Schurr responds when somebody actually complies in the smallest amount of way, watch this interaction. Look at his body language. Listen to the tone of his voice. When Patrick Lyoya says, it's in the car, get it for me. Does he scream at him? No. He steps back, literally steps back, get it for me. So what follows after this is a series of decisions by both of them. Patrick Lyoya is making decisions. Officer Schurr is responding to those decisions and making decisions of his own based on his training as a police officer. He's doing his job. Patrick Lyoya decides to walk away from police. Why? We don't know. Officer Schurr is trained, though, that failure to comply, ask yourself why. There's not a lot of good reasons for doing what he did. So he's alarmed again. So he went from, get it for me, please, to, oh, here we go. He's walking away, so I have to go back up. He decides he's walked away, I'm going to have to arrest him. Why? Because as a police officer, he's committed a crime. And it's not his job to decide who gets set free and who gets arrested. His job is to arrest. He is on the street to detect crimes and arrest people for them. And it's committed right in his presence. He doesn't think, well, I'm not really going to arrest this guy today. That's not his job. So then you saw that Mr. Lyoya, after Officer Schurr lawfully went to arrest him, resisted arrest. And we can argue about all day whether he affirmatively punched him, but balling up your fist and throwing arms like this, I agree he didn't face up to him that many times, just a couple times. He shoves him, and then he decides to run. Why is he running? Officer Schurr doesn't know. He doesn't even know his name at this point. Officer Schurr does his job. He calls it in immediately. Gets on his walkie-talkie. All right, somebody's running, and he catches him. He's arresting him. Feet from the car. Why? Because he's a police officer, and that's his job. He's doing exactly what we expect him to do. He doesn't get to decide, well, I'm just going to let this person go. That's an option under his training, but he made the choice to pursue him. And Professor Stoughton agreed that the initial pursuit was fine. He's just mad that he disagrees with the fact that he didn't peel off once he got near on the other side of the car. And you saw that Patrick Lyoya continued to resist arrest. He lifts him off the ground. Why? Yeah, he's getting away. But Officer Schurr is not trained to figure out what the motive was for the fact that he's resisting arrest. He's just resisting arrest. He doesn't have time to ask him questions. Why? Please just stop. He's not answering anything that he's saying. He's telling him to stop. So Officer Schurr decides to use greater force because he's a police officer and that's how he's trained to handle it. Knee strikes, commands, open hand blows. You heard that they were open hand. So he's not trying to hurt him permanently. He's using his open hand. That's how he's trained. And obviously, they're not effective. He didn't take out a stick and hit him on the head or anything like that. He's trying to arrest him. That's why he's using intermediate force. He's trying to get him to command, to comply within the bounds of his training. Then you see Patrick Lyoya, he decides to get up and walk across the lawn with the officer in tow. Officer Schurr doesn't know why, but it's not his idea to go that way. Who's in control of this situation? He gets up. He walks him across the yard. Intermediate force didn't work. You hear Mr. Lyoya yell, "Get the keys." Well, it sure looks like he's developing a plan to get out of there. So Officer Schurr has decided, he just wants to get in his car and go away, so I'll just let him go. No. It's his job to arrest people that are committing crimes. He can't just decide, I have to let him go now, because he's saying he just wants to get his keys and get out of here. The suspect doesn't get to decide when you get arrested. So he pulls out his taser. That's the next step up. It's perfect. Everybody agrees it's perfectly appropriate to use intermediate force here. Fires the taser. As everybody agrees, Mr. Lyoya grabs it and moves it to the side. That was Mr. Lyoya's decision. That wasn't the officer's. He didn't say grab the taser because he put it in front of him. This is not an affirmative act of aggression, reaching out. He grabbed it and he never let go. And he tries to get it from Chris. And look what the officer's decision here was. Did he pull out his gun? No. Did he go to deadly force here? No. He decides to physically try to get it back. He's got the taser in his possession. He won't let it go. And Patrick Lyoya decides he's not giving it back. The officer's yelling at him to drop the taser. Let go of the taser. And then the fight is on. They both want the taser. That's what they're fighting over. And Officer Schurr has a right to it, and Patrick Lyoya does not. And Officer Schurr did not use deadly force to get back the taser. That is not why we're here. They go to the ground, and the film goes in and out because Mr. Tuyashime I'm sorry, Your Honor, is there something wrong with the camera?
The screen went out for a moment. It's back on now.
Thank you. So you see this part of what's going on. They're both still trying to get it back. And you notice that there's a part where it starts in Mr. Lyoya's left hand. And then it's in his right hand. And 11 seconds go by. And you can't really see what happens. So we don't really know how Mr. Lyoya got it in his right hand, but we know it was in his right hand. And then you see Mr. Lyoya roll over onto his stomach. just like previously by Mr. Butler's house. He started on his stomach, pulls his knees in, and gets up. And that's exactly what's going on here. The taser is now in his right hand. Officer Schurr's trying to get the taser back still, and he can't. It's been switched. He's got exclusive control of it. He's on his back, yes, but why is he on his back? Because he's trying to get the taser back. And then you see Officer Schurr still trying to get the taser back. He's over the top trying to get this thing back. And you can see on the exhibit that it is in Mr. Lyoya's right hand. Right there. These slides, half a second apart. Half a second. This is how quick this is happening. It's a literal split second. Patrick Lyoya has got it, holding it in his right hand. It appears from the video, it's consistent with the officer's testimony that he's holding it like a gun. It's clear in the video that it appears that Officer Schurr is being lifted up. Is he jumping up? No, he's being lifted up by Mr. Lyoya. And the angle is turning, consistent with the officer's testimony. And here, this is no longer about arrest. This is the decision you have to judge. Whether in the moment of the threat, he was afraid of that taser, incapacitation, or great bodily harm. Whether it was reasonable for him to make the decision he never wanted to make that morning. Christopher Schurr was at work, and he was faced with the toughest decision of his life in half a second. That's what you're judging. Whether it was reasonable in that split second for him to think that an officer could be in fear of the taser. Not whether, what did Patrick Lyoya intend to do with it? He's holding it like a gun, and he's getting up. He has no idea why Patrick Lyoya is fighting this hard. And he doesn't have time to figure it out. 3 years later, when you hear about his family and his friends, yes, maybe you can draw some conclusions about what he was actually thinking. But he doesn't have the luxury. He's got half a second to make up his mind. And at this point, Mr. Lyoya has given him absolutely no reason whatsoever for him to believe he's not going to use it to get away. It doesn't matter why he's got held like a trigger. I mean, if he's just trying to get away, he's still going to disable the officer to get away. So here we are in a criminal trial. And so now you're asked to judge not what the best practice was, but whether or not in the moment of the threat, whether the prosecutor, with his burden, proved to you beyond reasonable doubt, all reasonable doubt, that he wasn't in fear. And to help you decide this issue, the prosecutor brought in some experts. You heard from Mr. Childs, Professor Stoughton, and Mr. Bloomfield, because he is trying to prove to you beyond a reasonable doubt that it was unreasonable for Christopher Schurr to be in fear. Beyond a reasonable doubt. And you heard from Mr. Childs. He works at Axon. It's the company that makes the taser. So he is an expert in tasers. A taser is a weapon. That's how they refer to it. And it's something to fear. The taser can cause incapacitation. even if the probes are discharged. If used improperly, a taser can blind or possibly even kill you. Probes can be reactivated once fired if they're lying on the ground. All you do is hit the button again. The wires can cause, even with wires, they can cause NMI, this incapacitation. They're insulated, but it's not a big insulation. It can get scraped off, especially if they're being dragged across the ground. The very next witness is Professor Stoughton. And followed him as Mr. Bloomfield. They wrote a joint report. And they've never heard of Brian Childs. Not really sure who he is. Didn't consider his opinions about the taser. How is that possible? They just flew in, gave their opinion, and flew out. It was their opinion. It's reasonable to use deadly force if going to be incapacitated. So they agreed. If you're going to be incapacitated and you're a police officer, you can use deadly force. It's reasonable to use deadly force if you're going to suffer great bodily harm. You don't have to lose an eye before using deadly force. That's what that means. But then here's where it differs. No objectively reasonable officer could be in fear of incapacitation from the taser because no reasonable officer could have feared incapacitation or great bodily harm in this particular situation. In other words, the taser is not dangerous in this situation. So you heard from Brian Childs, and then you heard from Professor Stoughton and Mr. Bloomfield. And they completely disagree with the prosecutor's own expert on tasers. They say a taser is not a weapon or something to fear in this situation. The taser cannot cause incapacitation if both probes are discharged. It's unreasonable to think the probes can be reactivated after being fired. Wires cannot cause incapacitation if insulated because it's so unlikely. The taser is about as dangerous as a thumb in your eye. And even Mr. Bloomfield, unless you're holding it like a gun. So you have the prosecution's own experts disagree with each other. You know what this picture is right here? That's reasonable doubt. You don't have to go any further. They're disagreeing with each other on the basis for why he should or should not be in fear. How can you convict someone for acting unreasonably and not being in fear when their own experts disagree? And certainly not beyond a reasonable doubt. Now, Mr. Stoughton and Bloomfield offer some more opinions. They admit they don't know how he's trained. And they essentially admit that there's no bearing on the ultimate issue of whether he reasonably could have used deadly force. But it has no bearing. These other opinions about the chase and the standing too close. Why are we discussing this? You're asked to determine whether or not the prosecution has proved beyond a reasonable doubt that he was in fear at the moment of the threat, and then whether it was reasonable. Why are we talking about GRPD chase policy? Because they're trying to distract you from the actual issue. And even if you consider it, I mean, it doesn't matter if he chased him improperly. It doesn't matter if he's within 4 feet or 7 feet. And it doesn't matter if he used a compound sentence in his warning or is just a directive. The issue is reasonable fear. And that's why you saw all this evidence about tasers and this training. They just don't agree with each other. You don't have to go any further. The prosecutor is also suggesting that you should just let him get away. let him go. He hadn't punched him. That's the standard for when you get to use deadly force? Well, up to now, I know he just took my taser, he's holding it in his right hand, but he hadn't punched me yet. So therefore, no reasonable officer would think that he was going to use the taser on him. None. That's what they're saying. That's what Professor Stoughton said. It's absurd. Not one officer, no reasonable officer. That's what he's saying. No one could think they were in fear. No one could think that he might use it on them. He's got to figure out that he's got some innocent motive for taking the taser from him after getting up 3 times before. Watch the video. If this issue, does he run away once the taser comes out, or does he turn around and grab it? Does he deflect it, or does he hold on? If this was reflex, oh, I don't want to get tased, you just deflect it. Does he ever say, hey, don't tase me? Does he throw it away once he has it? Does he listen to anything Officer Schurr is begging him to do? Is it transferred from his left to right hand? Why would any reasonable officer think he was going to walk away politely? In the split second that Chris had to decide whether or not he poses an imminent threat, all he knows is he's fighting to retain control. He knows he's lost the taser. He knows that he's turning and rising. His fear is unreasonable? No reasonable officer could think that. You should find him not guilty after the government's case. And even though we're under no obligation to put on evidence, because his entire life is on the line, we put on substantial evidence that the prosecutor cannot show that his fear was unreasonable. And we're constantly hitting these shifting arguments. You heard from the training officers, captains, Siver and McCursey. You saw a lot of training materials. Why is this relevant? Because you're considering the knowledge of the officer, not generally accepted police practices. They may coincide from time to time, but you're looking at what, he's a street cop. He's trained. Hours and hours of training. You saw a lot about taser training. Why are you seeing this? Because this is what's in his head of what happens when you get hit with a taser. I mean, is there any doubt that the training puts the fear of God in these guys about these tasers? They're weapons. You heard about firearms training, deadly force scenarios. One of you asked if they have implicit bias training. They do. This is a heavily trained department. And what is the point of all this training? Let me tell you about training. Officers are put in situations like this all the time, and you train because when you don't have time to make a reasoned decision with all the facts about everybody, you rely on your training. So when the time comes, you have to make a decision, you can act quickly. The same thing, military drills, sports, if you ever played sports, what do? You practice. So it comes almost automatic. When you don't have time to think in stressful situations, you rely on your training. All right, Captain Siver, he's a training officer, expert on GRPD policy and training. He testified that Officer Schurr trained on GRPD policies and trainings, not generally accepted police practices. Followed GRPD policy and training in the situation. Once a decision was made to use deadly force, he's not required to try other options. It's the decision to use deadly force. A reasonable officer in this situation could have used deadly force. Mr. Becker, question that Captain Siver didn't do an expert report. This does not matter at all. It's irrelevant whether or not he did an expert report. He was paid exactly $0. I know you heard a lot of paid experts. Captain Siver isn't one of them. Captain McCursey. He's an expert in GRPD training and tasers. What did he tell you? Officer Schurr was given warnings that taser is a dangerous weapon. If someone gets your weapon, assume they're going to use it against you. A taser can incapacitate you and probe or drive stun. An officer does not have to wait before being harmed or killed before resorting to deadly force. And a reasonable GRPD officer in this situation could have used deadly force. He followed his training. The captains in the GRPD believe that he was reasonable in this situation. Now, let's talk about the prosecutors' experts on GRPD training. Here they are. None. So everything that involves his knowledge, you heard from the defense, and nothing from the prosecution. How did they show you he didn't follow his training? They didn't call a single GRPD officer. You know why he didn't call one? It's his burden to put on proof. Ask that question yourself. How else has the prosecution failed to meet its burden? We heard about exhaustion. Heard from Lombartel. It's reasonable for an officer in Schurr's position to lose ability to continue fighting. In a fight, you lose ability to contract muscles within 30 seconds. He was in a position of tactical disadvantage, not advantage. He fought with him for 2.5 minutes with a man that was larger than him. He's got nothing less, and he lost control of his taser. Or from Dr. Kroll, he wins the award for the smartest witness. He's a biomedical scientist. Why are we calling him? Because we're trying to refute this testimony by Professor Stoughton, who is not a taser expert, that you can't be incapacitated by this thing. So if you think that Professor Stoughton actually knows more than Mr. Childs, we called another expert. Drive stun can temporarily incapacitate you through disorientation. You have the probes, and then you have the drive stun. A scientist came and told you, yes, you can be temporarily incapacitated. And Professor Stoughton agrees, if you can be incapacitated and you're in fear of incapacitation, you can use deadly force. The drive stun can and has caused great bodily harm to sensitive areas. You heard this whole thing from Professor Stoughton. There's no reported deaths of police officers who lost their tasers as officers trained after they lost their tasers where someone took their gun and killed them. And you know why? You also heard that answer from Dr. Kroll. Because officers are trained to use deadly force if someone gets your taser. That's why. He told you how many deaths there were. You heard from Dave Blake. Well, you first heard from Mr. Bloomfield that this is not the type of situation where auditory exclusion and tunnel vision or this sort of closing in, it's not stressful enough. And then he was asked, are you an expert in human factors? Well, no. Well, this is Dave Blake. He is. He said this is exactly the type of case where this could occur. And that Chris did not have time to give a warning. That's it. That's how much time he's got to make up his mind. That's what you're judging him on. And that decision, not whether he chased him a minute and a half before, that's how much time he's got to decide, and whether that was reasonable under those circumstances. The prosecution suggests that you shouldn't credit Dr. Blake's testimony because he went to an online school. But yet, he wants you to credit Mr. Bloomfield's testimony, even though he didn't go to school for this. I'll let you decide who's more credible. So you heard from the use of force experts. They pretty much agree on a lot of stuff. We agree on the standard as trained. When you're in fear of great bodily harm or death, that means they can't you're not worried about a paper cut. It's got to be like stabbing, breaking a bone, or losing an eye. And of course, death. Then if the prosecutor could show beyond a reasonable doubt that he wasn't in fear at that moment, that's the standard. You heard about the totality of circumstances. And you can go through these. These are the things you're supposed to consider when reviewing whether or not the decision to use deadly force was appropriate. And we agree that a lot of these things applied. But that doesn't mean he shouldn't have tried to arrest him in the first place. This just means, under the totality of circumstances, the decision to use deadly force was reasonable. You know what's not on there? Foot chases. Because it doesn't matter. It's the decision to use deadly force that you have to consider. And he was bigger than him. There were multiple people. He was stronger than him. He got his taser. He's in a bad tactical position, or if you believe Professor Stoughton, he's in a better tactical position. The fitness level, the exhaustion, it's raining. He's getting up with the taser in his hand, and he's right next to him. All these factors point to a positive decision to use deadly force. You heard from Officer Gady. He's a firearms instructor. It's deadly force is deadly force. All the experts agree on this. It's the decision to use deadly force that you're judging, not the location of the shot. Not one expert said, oh, you have to try to wing him or hit him in the hand or hit him in the side. That is not what these experts are saying. It's the decision. Am I in fear of imminent threat? Is there an imminent threat? Then I can use deadly force. The manner of deadly force doesn't matter, and everybody agrees to that. Where do they disagree? Well, you heard that the prosecutor's taser expert and the prosecutor's use of force experts disagree. And you also heard that their use of force experts didn't really rely on GRPD policies and Michigan law. Instead, they have this generally accepted police practices. And that's because Professor Stoughton and Mr. Bloomfield, they're viewing this in hindsight, and everybody agrees you shouldn't do that. It's a sort of a woulda, coulda, shoulda thing. If you go back in the jury room and say, you know, if he just had let him go, that is not the proper analysis. I wish he just, I guarantee Christopher Schurr wishes, in hindsight, that he had let him go. He didn't want to make this decision. But that's exactly what the prosecution is doing here. Monday morning quarterback, based on all kinds of issues that don't matter, it's the moment of the threat. Look at his training, his knowledge, what he knew. And you take that into that situation, and you decide that based on what was in his head, the decision to use deadly force was reasonable. In this case, they have to prove beyond a reasonable doubt that it was unreasonable. Now, you heard Chris testify. He had no obligation to testify. It's a criminal case. What did he tell you? He testified about his knowledge, his training, and experience. He was exhausted, running on fumes. He was alone. He called it in right away, but there's nobody there. You can listen to the video. Do you hear any sirens at the moment of the threat? Listen to it. Crickets. Where is everybody? He testified he did everything he could to avoid using deadly force. He didn't pull out his gun as soon as he grabbed the taser. Probably could have under this training. What did he try to get it back? And he's screaming at the guy, let go of the taser. It's the moment of the threat. He testified that he saw the firearm. Let's get that. in his hand. He was trying to he testified he's tried to put the safety on, even. Couldn't do it. He's in a bad position. He does not feel like he's safe. He's pulling himself up again, and look at what Mr. Lyoya had done 3 times prior. Literally lifted him off the ground, and now this time he's got the taser. It's reasonable for an officer to think in that situation that he's going to use it on him. It would be unreasonable for him to think he wasn't. But when he's given a chance, he comes into the stand to cross-examine him as vigorously as he did Captain Cyber. He barely even asks him about the moment of the threat. What is he asking about? You didn't have to chase him, right? That's the questions they got. You stand too close to him. You're in really good shape, aren't you? That's just designed to mislead you from the issue that is why you're here. He suggests that he's lying about the second pop because he said, look at the statement. Did he ask him about hearing it? Nope. He just wants you to look at a statement that was done. As Christopher Schurr testified, I kind of wrote it like a police report after seeing the video. I mean, this video was out there right away. That wasn't his fault. And then you have the state police asking for a statement, and he's got counsel already. And he signed it, so it's attributable to him. But keep that in mind. View the actual evidence, the testimony. The prosecutor has a chance to ask him all these questions. Now he asks you to answer based solely on a statement that was written with the help of lawyers a few weeks after the incident. That's not fair. He didn't have to testify, he did, and then he didn't ask him any questions. How can you assess his credibility on these issues when he wouldn't even ask the questions? All you're left with was what he said originally, but it wasn't the focus of cross-examination. No, it's something he wrote kind of like a police report because he's a police officer. And look at this exhibit right here. If you're wondering whether he's exhausted, I know he's in good shape, but 2.5 minutes trying to wrangle a grown man, desperately trying to get a taser back, is not the same thing as running on a treadmill. So you're going to hear about the law, and I think I have already stated over and over again what the issue is. Nowhere in here will it say, please consider whether or not Officer Schurr's complied with policy. Nowhere in it will say, hey, maybe we should change GRPD's foot policy. Please give us your thoughts on that. No. That's a distraction. Go to the next one. The relevant consideration is not what the defendant should have known or done, but rather what a reasonable officer with the knowledge and the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. That's why we're here. Professor Stoughton and Mr. Bloomfield say it was no reasonable officer could have thought he was in fear. We don't think the prosecutors come close to meeting that burden. If you start discussing whether or not GRPD should have a foot pursuit policy, stop, because that's not relevant. Look at the moment of the decision. It's the decision. Please, just look at the decision and whether or not there is enough there for any reasonable officer to think he might be in fear of harm. You're going to hear also that police officers do not have a duty to retreat. And this is important because private citizens do. Like if he wasn't a police officer and you saw this, then yeah, he put himself in a position he shouldn't be in. But Officer Schurr, he's not supposed to be retreating. He doesn't have a duty to retreat because he's a police officer. He put himself in danger, yes, because that's his job. You heard from one of the officers about the cowardice policy, just letting people go. You have to be sure that he wasn't in fear of great bodily harm or death before you can convict him of murder. Now, if we go to the next one, please. Honestly, or go back, I'm sorry. One more. It has to be an honest and reasonable belief. But you heard from Officer Schurr. Judge him on his testimony. And judge him, his testimony in comparison to what you saw in evidence from the video. You heard him say that Mr. Lyoya had exclusive control of the taser, and he did. You heard him say that he was completely exhausted after a minute, and you saw how he was 4 minutes after. And if there's any question whether he feared that taser, whether he had an honest belief, if he doesn't fear it, ask yourself, why is he trying to get it back? What is he, even after the second discharge? Does he stop for a second and slow down after that second probe goes? No, he's still going gangbusters trying to get it back. Why would you turn the safety on if it's as dangerous as a thumb? It doesn't matter what Professor Stoughton thinks about thumbs and tasers. It matters what he thinks. And look at the video. Does he slow down for a second? He's fighting as hard as he can to get that thing back. He's going over the top of him. He's putting himself at harm. Yes, because he's trying to get it back. Reasonable? This is what the prosecutor thinks is reasonable. No reasonable officer could have thought that that taser, with the probes discharged, could harm him, could incapacitate him. None, not one. These guys who didn't even talk to the taser expert for the prosecution, who disagrees with that completely. If no reasonable officer could have been in harm or thought he could be incapacitated, then why does everybody else that's called to the stand think you could, including taser experts? Especially when handled by an untrained person. Now you're going to hear a separate jury instruction on manslaughter. It's the first time you're hearing this. This is the prosecution recognizing this case is weak. It's a lesser included. It's for cases where someone didn't intend to shoot the gun. Officer, he got up there and he told you, yeah, I intended to use deadly force. I intended to shoot him. But it was justified because he had the taser and I was in fear. This is not a situation where someone gets in a fight and they don't really intend to kill him, but they lose their cool in the heat of passion before they have time to cool off. They kill someone and didn't really intend it. That's a lesser included. That's not this case. And justification of self-defense is a defense to both of them. So if you find that the prosecutor hasn't met his burden to show that he was unreasonably in fear, then you must acquit to both of them. You absolutely cannot convict him of murder or manslaughter if you acquit him of murder. Now, you've heard a lot about the burden of proof. And it's important. This is a criminal case. It's not a civil case. I think a lot of you were asked during the voir dire whether, it's got to be one of the it's one of the most important decisions in your life, like buying a house. I agree. It's got to be, this decision is as important as those. And this is the highest burden under the law. I like to equate it to, you have a friend, family member who's on life support, and you have to decide whether or not to take them off life support. That's how important this decision is. It's any reasonable doubt. Now, the wiggle room in there is if it's not reasonable. If it's an unreasonable doubt, then that's not something you should consider. It has to be a reasonable doubt. If you have any sliver of reasonable doubt, then you must acquit. They have to prove beyond a reasonable doubt that he wasn't in fear and that his use of deadly force was unreasonable. If you're back to saying, well, he might have been justified, you must acquit. He could have been justified. Not sure whether he acted reasonably or not. That's an acquittal. That's the burden the prosecutor has to show before this is murder. And we just ask that you judge him on the decision and not all this noise around it. It's the split second. Any reasonable officer? This isn't murder. What an impossible decision. Make up your mind. It's not murder. It's not manslaughter. This man did not commit a crime. No one is saying Patrick Lyoya deserved to die. That is not what this is about. It's about, in the decision that we've asked Christopher Schurr to make, in that moment where he's supposed to be, whether the prosecutor's shown beyond a reasonable doubt that it was unreasonable. No reasonable officer could have used deadly force in that situation. That's the standard. And their experts don't even agree on what's dangerous. You must acquit him of both charges. Thank you.
So again, attack prosecution's experts. That's one of the things you got to take a look at. You got to take a look at the credibility of witnesses. This is one of the instructions you're going to get. Does a witness have any bias, prejudice, or personal interest on how a case is decided? And that includes the experts. That includes everybody here. So you want to compare experts here. Let's compare for science. For Science is not an expert entity. For Science is an advocacy group for police officers. That's what they're there for. Von Cleveland, and that's their network. That's their whole thing. So you want to compare about why not to believe somebody. Why would you believe an entity that starts out with giving the benefit of the doubt to the officer? That was Von Cleveland's testimony. He starts out. So how can you be impartial? How can you be coming from a position of neutrality when you start out? You're going to give the benefit of the doubt to the police officer, which goes into them finding 98% of the time officers acted appropriately. What other profession is that infallible? What other profession? Name one that they're correct 98% of the time. So that goes into how do you believe they're experts? Yeah, they paraded a bunch of experts out here. And it gives you just an insight of what happened. If you guys remember my question to Mr. Bartel. I said, well, geez, MMA goes 5 minutes, right? MMA goes 5 minutes. Well, that was the dumbest question ever made in the history of cross-examinations, because the disdain from the stand just oozed out of his pores. How could you can't compare an officer to an MMA fighter? MMA fighters train for 3 hours a day, so whole years, and blah blah blah. Yet, the next day, when Von Clean, his partner, his friend, who he presents with all the time, what does Von Clean do in his report? Compares Patrick to an MMA fighter, because that's what they got to do. They've got to say the opportunity, he has an opportunity because he can spring up like an MMA fighter. That gives you a window in terms of the prism. They translate what happens based on an officer. They like officers, which is perfectly fine. I'm not saying that they shouldn't have advocacy groups for officers, but you judge an officer by one standard, then you judge the victim by another one. That's the opportunity. That was a tactical advantage because why? Because Von Clean and Lon Bartels do jiu-jitsu and they do grappling. And so ergo, that Patrick has the same opportunity because he can suddenly spring up from a face down or a face on his back position and maybe use the taser. That's what gives him the opportunity. Von Clean talks about, disproportionate resistance. That's their intent. That's his interpretation. That's what he said. Well, you can determine the intent. Disproportionate resistance by Patrick is why you can think he's going to use deadly force. Von Clean doesn't want to use that against police officers because they have no idea how can they come up with disproportion. They can't comprehend that. So when you want to talk about bias and prejudice against the experts, you want to criticize ours, take a look at theirs. And then they're comparing apples and oranges. Because our experts are use of force, they say, in terms of taser, what a taser does, what a taser can do. And it's possible for these things to happen, but it's not reasonable to think it is going to happen. That's the reasonableness test. You can't look at every sort of possibility in the universe of what might happen and then say, oh, it's reasonable that you can do it. I mean, why does anybody take weed gummy? You listen to all the bad things that can happen on any of the drugs that are on TV because they may cause, hair loss, liver problems, and so on and so forth. But they want to use that as justification because all this may happen. It could, the wires could. There is no, talk about distractions. There is no evidence the wires were broken. There is no evidence that anybody was feeling MNI. There's no evidence that wires had any impact. But they got to throw out all these things. You want to talk about another thing? Why isn't GRPD? Why do we ask for GRPD? Does a bank, when somebody embezzles money, investigate their own? No, they call it an independent. They call it an outside organization. How hard is it? And this is not just GRPD, this is for anybody. How do you judge something that you train? I mean, Captain Cyber said, hey, I was his commander at one point in time. You think they're coming from a position of not bias because you're asking them to judge their policies, their procedures, and what this person does? They like him. He's a good guy. How do you come in and say they're impartial? And once again, to give a window on that, what did Captain Cyber say? Because Captain Cyber, when we asked, we said, okay, you've been listed as a defense witness. Okay, what's the policy? If somebody's disarmed with a taser, do you have a policy on that? Nope. No policy. Never heard of it. Yet then he takes a stand in front of you and says, oh yeah, that's deadly force. Well, wait a second. 2 weeks ago when the detective asked you about it, you said, no, there's nothing. But now as soon as somebody disarms you of a weapon, that was a weapon. You never said taser specifically, but he was asked specifically about a taser and disarmament. No, there's no policy on that. We don't train nothing about that. But yet all of a sudden it changes. That gives you a window of why there's bias. There's a conflict of interest. That's why we have the state police in here talking about it. There's a conflict of interest to try and bring GRPD officers to judge on another GRPD shooting incident. They have every reason, just like anybody else. Just like a bank, you don't ask the people who were responsible for training what went wrong. But even then, and this is what I'm talking about, you can believe all, some, or none. They say Grand Rapids policies are generally accepted police practices. They're one and the same. There's no difference. Both of them say that. So to create this, he doesn't know what generally police practices are because he wasn't trained on them. It's just a fallacy because it's one and the same according to GRPD. But the other example is Officer Gady. Why couldn't he talk to the officer? No, I got better things to do. he doesn't want to talk to an officer to give him, I'm not disputing. That's not a dispute. Yeah, when you use deadly force, that's what's trained. You use deadly force, you're going to shoot to kill. They're not going to try and shoot an arm off. They're not going to try and shoot a foot. That is, why do you want to talk to the detective about that? And so he trains, he was part of his recruit class, it's somebody in-house. You can't ask somebody in-house to be completely impartial and unbiased when you ask them to do stuff like that. But when you look at it, when you think about it, when you try and compare in terms of what's going on between these experts, compare the experts, what about Sergeant, I think it was Johnston, the first sergeant on the scene? Let's remember his testimony. Remember what he said? Did he or did he not sound like Seth Stoughton? Because he was worried. He said, yeah, we pulled up. I couldn't see inside that car. I didn't know what was going on in that car. I didn't know what the individual that was standing outside the car had. He could have a gun. That's what we teach. We don't know what's going on. I mean, that's the thing. He's got 3 officers at the time, all with handguns drawn. And look, watch the body cams. How carefully they approach that car because they don't know. That's what they're trained. So it's kind of a contradiction in terms to say, yep, it's okay for a single officer all by himself to run after and chase and tackle somebody, which flies in the face of their policies that says don't do that you saw. That's a big difference there. How can you chase if they're treating everybody, 3 officers on scene being that careful? Why is 1 officer all by himself? That's okay. That's fine. And so it's not distraction. So what is the purpose of the reasonableness of the officer's actions when you're looking at the totality of the circumstances? If it's just as many times as you snap your hands, there's no totality of circumstances. It's just looking at that moment, period. And what's the purpose of the totality of circumstances? Looking how the officer got into that situation. There is no purpose. There is no totality of circumstances. Well, he was somebody had a taser, you can shoot him. And the interesting thing was, because who did they say? Who did he say? Well, Professor Kroll. Professor Kroll is the one who said, oh yeah, they're able to use deadly force because he did that study. Professor Kroll isn't a taser expert. He has no idea of police policies. He said, that was his testimony, it was his impression of police policies. Because they can't bond clean, the GRPD officers, nobody can say anything about what the taser policy. There is no. Take a look at all the policies. Take a look at the policy where it says if you're just starting the taser, you can use it. You can shoot them. Because it's not there. There is no policy. It's based on the totality of the circumstances, based on everything the officer knew at the time. And what the officer knew at the time goes back to when the incident started. The whole thing, not just looking at that one brief second. And why would a reasonable officer, when there's been no aggression, there's been nothing, no punching, no kicking, no hitting, no anything, think he was going to die because somebody had his taser? That's what's not reasonable about all this. And you're right. You're right, manslaughter is going to be brought up. And it was a complete misstatement of the law to say, well, manslaughter is not an intent to kill. That is not the law. Listen to the instruction. It is an intent to kill. The traditional manslaughter thing is when a spouse shows up and sees their spouse in bed and loses it. That's your typical manslaughter. You lose it and they want to kill him. It's not, well, they got into a fight. A manslaughter instruction is because of emotional excitement. Because of emotional excitement, somebody who's driven to kill somebody. That's what we're talking about here. It is not just, well, there was a fight they didn't mean to. That's a completely different thing. Manslaughter, listen to it. And because of emotional excitement to the point a reasonable person may have acted in impulse. And if anything, that's what their experts are talking about. That's what their experts bring up. Yeah, Professor Lake. Yeah. Heuristics. Heuristics. And I said, yeah, heuristics. It's kind of, putting in layman's terms, that means jumping to conclusions. And that's it right there. He doesn't know why he's running, so he jumps to a conclusion. The defendant jumps to a conclusion. Well, there must be something worse here. There must be something worse here. I'm going to jump to the conclusion and think it's a bad thing. That reduces it, so it's justified, excused, it reduces it to a lesser crime. Manslaughter is a lesser crime, so if you think this fight, if you think this battle, you need to characterize it as a battle, because what it is a wrestling match. And that's in the totality of the facts and circumstances. How does somebody want to kill you when they don't do anything else before that? How do they want to kill you? What evidence do they want to kill you? He grabbed my taser, and I'm tired. That's not enough. that is not enough to justify taking another person's life. And watch the video. Yeah, take a look at the video. Yeah, he stands up 3 times, but at the moment he goes to push himself up, the defendant shoves him back down. He shoves him back down. He's got total control over this incident. So to think that he has to kill him at that moment is just wrong. It's not reasonable. Yeah, no reasonable officer would come up with that. Yeah, why? No idea why it's so far. Where's the fight? It's not a fight. It's a wrestling match. I thought the other thing that was, interesting about, GRPD puts the fear of God. Puts the fear of God about tasers. Yes. Watch that video. Watch the graduation video. This is the graduation video. So the fear of God, you put that's a serious weapon, but the fear of God in an instrument that you put the soundtrack to Top Gun to in the graduation video, and take a look. Get a closer look. Look at the smiles. Look at the smiles on all their faces. Yeah, they're kind of. Somebody's going through it again. It's taking the ride. We're talking about taking the ride. Yeah, it's a serious weapon, but it's not a weapon that's going to cause death or great bodily injury. That's not putting the fear of God into him when you put it to the soundtrack of Top Gun. It's not putting the fear of God into him when you're sitting there smiling at him, smiling at somebody getting tased. It's something to be concerned about, sure. But this whole thing in terms of distractions, it is once again, it's amazing now, because now we're saying don't ignore the defendant's prior statement, ignore it, because it was just a police report. What we heard on the stand, that we couldn't trust his testimony in the stand either. Why? Because, Mr. Dodge asked him, well, you've been 3 years. There's a lot going on in those 3 years. You've been through a lot of trauma. So you can't really believe his testimony by his own, attorneys asking him questions, but then you're also not supposed to pay attention to his written statement. So how do you determine what it is? You gotta take it. That's what the statement's there for. Compare what the differences are. Take a look what it is. Take a look. Where did the bladed stance come from? Because that's what it says in his written statement. Where's the bladed stance? Because we heard what the bladed stance was by Captain Siren. Somebody may have a gun. That was a bladed stance. No testimony to that. It was in his written statement. And then I didn't ask him questions. Well, show us the bladed stance. Well, it's a different perspective. You really can't see. So, what we're trying to do is trying to build up the danger of Patrick. Trying to build him up. He had a bladed stance. It was dangerous from the get-go. Well, then if it's dangerous from the get-go, why are you chasing him? And that's part of the totality of the circumstances. You think you may have a weapon, you shouldn't be chasing them. That's what GRPD policy says. It's a bad idea to do that. And you've got to take a look at everything that led up to the decision to fire that shot. And simply getting up is not enough with the taser. He has gotten up 3 prior times and has done nothing. Has done nothing other than try and get away. But you're supposed to jump to the conclusion, using heuristics, jumping to a conclusion that he's going to kill you. That is not reasonable. It may reduce it. Maybe it's manslaughter, but it doesn't excuse it. It doesn't say, yep, go on away. You did nothing wrong here. So when you're looking at everything, it's a big decision. But a reasonable doubt, you'll hear, I've talked about it before, a reasonable doubt is a fair, honest doubt. But it leaves you firmly convinced. Firmly convinced based on the evidence. Based on the evidence that's presented here. And when you look at this, when you look at the facts, when you look at the evidence, should be firmly convinced that there was a homicide here. There was a murder. It was second-degree murder. It was a death caused by the defendant. He intended to kill, and there is no justification for it. Simply having a taser with nothing more does not think, well, I'm going to die. We've had all kinds of people up here saying, yeah, we survived. We got tased numerous times. Don Cooney got tased in the head. He's still talking about it. It lasted about 30 seconds. And even in terms of you want to talk about reasonable, use their expert. Use Professor Kroll. It's never happened. Never happened in the history of policing where an officer's been tased, disarmed his weapon, and killed. And it's his impression that it's because they kill. But the one thing where he said is it's happened 9 times where a person's actually been tased. An officer's actually been tased, but in the other case, the majority of the time, nothing happens. But they want to, every possibility to consider. You have to consider what's reasonable. If you have a reasonable doubt, then he committed the crime of homicide. At best, he committed the crime of manslaughter, but he is not justified. He is not excused. Patrick was not a threat. Patrick meant no harm. Patrick wanted to get away because he was drunk. or whatever. I think the only logical conclusion you have is you find it guilty. Thank you.
Members of the jury, the evidence